Contract English for ML data, Dataset warranties and no scraping. Welcome! Today we'll make your ML contracts sharper and safer. When you train a model, it can inherit legal risk from its data. Copyright, privacy, or terms of service issues can flow straight into your product. Vague contract language invites costly disputes, delays, and emergency retraining. Clear, specific clauses do the opposite. They set expectations, reduce surprises, and speed up decisions. Think of precision as model hygiene: clean inputs, clean outputs, fewer headaches. Our goal: give you practical wording and checks so both supplier and customer are protected, aligned, and able to move fast without sacrificing compliance. Start by defining provenance as the dataset's lawful source, plus the chain of rights from origin to you. Spell out who collected the data, who licensed it, and by what methods. Name the collectors, licensors, and intermediaries, and describe whether data was user-submitted, curated, or acquired from public datasets or commercial databases. Require a data inventory or schedule, listing sources, license types, usage permissions, and any constraints. This turns hand-wavy assurances into a verifiable map, so if questions arise later, you can trace each record back to an identified, lawful source. Require a clear warranty. The supplier has valid rights to grant the license you need for training, evaluation, and deployment. They confirm there are no hidden third-party restrictions, no surprise approvals, royalties, or non-transferable terms. The warranty should cover compliance with copyright, privacy, and contractual terms tied to the data, including platform terms. Add that rights are sufficient for intended uses, fine-tuning, embeddings, caching, and derivative model outputs. If the supplier is unsure, they must disclose limits upfront so you don't discover gaps during launch week. Protect yourself with a representation that data was not obtained via prohibited scraping. That means acquisition-respected website terms, robots exclusions, and any explicit access rules. State that the supplier did not circumvent technical measures like paywalls, rate limits, or CAPTCHAs. If automated collection was permitted, require proof, documented permissions, API terms, or licenses. Include a forward-looking covenant, no future ingestion from banned sources. This reduces platform disputes, minimizes takedown risk, and signals to your compliance team that the dataset was gathered with attention to both ethics and enforceable rules. Ask for robust audit trails. The supplier maintains collection logs, source URLs, consent records where applicable, and the license or terms in force at the time of capture. They version the dataset and timestamp all changes, including removals and enrichments, so you can reproduce training inputs. On request, they provide audit access or a third-party attestation, balancing confidentiality with verification needs. These artifacts turn compliance from a belief into evidence, crucial when answering regulators, security teams, or customers who want assurance that your model's training data was acquired and managed correctly. Build a fast path for issues. The supplier must give prompt notice of any claim, demand, or DMCA complaint affecting the dataset. They agree to suspend, quarantine, or replace disputed content while the claim is assessed, preventing further training contamination. Require a clear remediation log: what was alleged, what was removed or replaced, and by when. Include timelines for response and final resolution, plus cooperation on model impact analysis, retraining, redaction, or output filters. This playbook turns panic into process and keeps your release schedule intact, even when surprises appear. Secure an indemnity where the supplier defends and settles claims arising from data sourcing, including IP, privacy, and terms of service violations. Exclude these from the general liability cap or set a higher cap. IP and privacy breaches are high-severity risks. Give you the right to purge affected data and derivatives, and to receive a clean replacement dataset or credit. Add ongoing cooperation, notices, defense control, and approval rights over settlements. These remedies align incentives. Suppliers vet sources carefully, and you have concrete protection if something slips through. Make your contract readable and enforceable. Define key terms once. Dataset, outputs, training, deployment, and reuse them consistently. Use shall/will for obligations and may for options. Avoid ambiguity by specifying scope, training, fine-tuning, evaluation, territory, where rights apply, and term, how long. Replace vague verbs with measurable ones. Provide audit logs within 5 business days, not promptly. Reference attached schedules for inventories and processes. Plain English doesn't weaken protection. It reduces misinterpretation and speeds agreement, so your teams can build without legal fog.